everyone! So today I'll be discussing cruel and inhuman punishment. So what is the cruel and inhuman punishment? This is in relation to Section 19, Article 3, still in the Bill of Rights of our 1987 Constitution. So Section 19, Article 3 provides that excessive fines shall not be imposed nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. And paragraph 2 says that the employment of physical, psychological, or degrading punishment against any prisoner or detainee or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. So, what do we mean by cruel, degrading, and inhuman punishment? So, a penalty is cruel and inhuman if it involves torture or lingering suffering. So, for example, being drawn and quartered. Also, our professor here said that what's this torture is actually what we call use cogens. So, use cogens is JUSCOGENS. So, it's something that is prohibited by law that is applicable to the whole world. Like torture is even prohibited for example, in the United States. It's also prohibited in other countries. So it's like a worldwide crime that is not really tolerated by any state, especially now in the modern world. So another is that a penalty is degrading if it exposes a person to public humiliation. So for example, being tarred or feathered, then paraded throughout town. So that's what we call degrading. So, namamahiya ka. So, what are the standards used? The punishment must not be so severe as to be degrading to the dignity of human beings. It must not be applied arbitrarily. It must not be unacceptable to contemporary society. It must not be excessive. It must serve a penal purpose more effectively than a less severe punishment would. So, what is an excessive fine? An excessive fine is when in any other circumstance it is disproportionate to the offense. So, in the book of Bernas, it says that the accused cannot be convicted of the crime to which the punishment is attached if the court finds that the punishment is cruel, degrading, or inhuman. The reason for this is that without a valid penalty, the law is not a penal law. So, excessive fine shall not be imposed. A fine is excessive, like we said, if it's disproportionate to the offense. So the old constitution used the expression cruel and unusual, and the new constitution drops the word unusual in order to allow for development of penology and uses instead degrading and inhuman in order to emphasize that what is at stake is the dignity of the person. It takes more than merely being harsh, excessive, out of proportion, or severe for a penalty to be obnoxious to the Constitution. The fact that the punishment authorized by the statute is severe does not make it cruel and unusual. Expressed in other terms, it has been told that to come under the ban, the punishment must be flagrantly and plainly oppressive, wholly disproportionate to the nature of the offense, as to shock the moral sense of the community. So, like we said here, the standards used is that a punishment must not be so severe as to degrade the dignity of the human beings. Like the example we gave a while ago na parading throughout town, then hindi dapat arbitrarily lang na basta-basta lang siya ina-apply. It must not be unacceptable dun nga, like to our modern contemporary society. So, the 1987 Constitution has suspended the application of death penalty. It may only be revived by law for compelling reasons involving heinous crimes. In the meantime, any death penalty already imposed shall be reduced to reclusion perpetua. It was actually revived in 1993 by Republic Act 7659, but later it was suspended. We always cite this in our criminal law class, yung RA 9346, which suspended the death penalty back in 2006. So ano ba yung death penalty? Hindi ba yun cruel and unusual? In the book of Bernas, it said no. The Constitution, by allowing the possibility of its restoration, implicitly admits that it need not be cruel and inhuman. However, the circumstances under which a specific law may allow the death penalty may make it cruel and unusual under such law. So the death penalty per se is not a cruel, degrading, or inhuman punishment. Punishment is, so if it involves torture or a lingering death or pain, but the punishment of death per se nga is not cruel within the meaning of that word as used in the Constitution. It implies there something inhuman and barbarous, something more than the mere extinguishment of life. So this ends our discussion, our short discussion and review for section 19. Thank you for listening, and please subscribe.